For judgment, item number 1, WPC 621618.
Pradeep Devnath. Okay. We are remanding the matter as far as the petition number 1 is concerned for press consideration. As regards remaining petitioners, the petition is allowed in as much as there was no inquiry, no reference.
For judgment, item number 2, CRPIO 1 of 21.
The petitioner is allowed to file the documents. Yes,
My lord, with the consent of other side, my lord, I beg to mention item number 6, my lord.
item number.
Item number 6, my lord. My lord, this matter will come after vacation, my lord. In the meanwhile, we will file our affidavit.
Mr. K. Singh, let them this application. Yes, next.
May I please, Lordship?
Yes,
Lordship, I beg to mention item 9.
yes.
Lordship, kindly matter the password for the day. I have some personal difficulty, Lordship.
On the prayer, Mr.
Yes, Islam.
Yes, Islam.
On,
Your name is not here.
Lordship, I
Item number 9, Montude,
Montude, Lordship.
who are you?
I am appearing on behalf of Ami Mahmood.
You say that you are not, your name is not here. You are not authorized. But since you are mentioning on, yes, Mr. Mahmood.
Immediately after vacation. Immediately
Okay.
after vacation.
On the prayer, Mr.
Yes, Islam on behalf of
M. Islam on behalf of Mr. M.
May I believe your lordship?
Yes,
Yeah, the petitioner's father was missing from 16/3/2022.
petitioner's father is missing.
Yes, lordship. And thereafter, the petitioners have lost an FIR before the police station, lordship. And when they approached the police found that there is no clue, unable to find out.
Okay, we'll issue a.
Yes, lordship. Some direction may be given to the respondent.
21st of October.
And Mr.
M.A. Mondal.
M. Mandolana counsel for the petitioner who submits that the petitioner's father has been missing since
16/3/2022.
16/3/2022. However, on inquiry, he has been informed that, and though a missing complaint was lodged before the police has informed him that there is no clue about his father. Be it as it may, let the authority file a
Status report,
status report as regards the progress of the case.
21st of October.
Huh?
Maybe fix on 21st.
Also Ms. Dasi
Mal.
for the state,
Mal.
who submits that she may be, she will place the same on 21st of
October.
October. This accordingly.
Yes, obliged, lordship.
Item number 2,
Yes,
Please, your lordship.
Yes.
Your lordship, the impugn order here is on page 14, your lordship.
we'll issue notice.
Lordship,
We'll issue notice.
lordship. In the meantime, I may be protected, your lord.
You are not yet been detained.
No, your lord.
Yes, Mr. Paying and Mr. Lana counsel for the petition issue notice number 4 weeks. Mr. Paying access notice on behalf of respondent number 2, 5 and 6. 2, 5 and 6 or what?
One, 2, 5, 5 matter, not 5.
No, acha. What about
2 and
6?
6 matter.
2 and 6. Yes. 1 Devi, yes. L Devi. 1 and
1 and 4,
1 and 4. Yes, 3,
4, 5, my lord.
4.
5, you does.
Udas. Okay. Udas. And 3.
3, election commission, my lord. This is AI Ali.
Yeah. Okay. Let the record be requisition. In the meantime, if the petitioner has not been detained, she may not be detained. However, she will appear before the SP border,
Sunitpur.
Sonipur, and furnish a bail bond of rupees 5,000 with schedule like amount. Full stop. To the satisfaction of the SP border, Sonipur, the SP border will also capture the fingerprints and the
Iris.
IDs.
iris what? No.
Iris.
Correct.
This is biometrics.
Biometrics of the iris, and also full stop. The petition also shall not leave station without informing the SP border, Sonitpur.
item number 3,
Yakub Ali.
Yes, Lordship. May I please, your Lordship.
Yes.
Lordship, here the petitioner is declared to be a foreigner, Lordship.
Yes.
His father's name is in the.
We'll issue notice. We'll examine.
Lordship, he is already detained, Lordship, in custody.
Detained,
He may be released, Lordship.
may be released.
And Lordship will examine the matter because there are documents, Lordship.
Hmm.
And even the two brothers have deposed on his behalf.
Two brothers also
Two
deposed.
elder brothers.
Two elder brothers. Yes, Mr. Pine. Two brothers are deposed. Two
Later
brothers-
records come, my lord, then it what's
Lordship.
considered on that defect.
But all these have been considered by the tribunal. Has the learned tribunal considered all this evidence?
No, Lordship, even the Gaupura was examined and that is also not discussed in the judgment. Lordship.
How do you say that show us? Show us that it was not discussed. What is the impugn order? Page.
Page, Lordship, it
Page
starts from
22.
22, Lordship.
Final order, cross-examination.
The
Abul
exam-
Hussain. The decision was filed. You are,
Paragraph-
no,
paragraph
who is this
four.
Abul Hussain?
Upon para 6, Lordship.
Who is Abul Hussain?
Abul Hussain is the brother, Lordship.
Brother.
Elder brother.
Then Ali Hussain,
Ali Hussain is also the brother.
brother. Proceeding.
And he has-
executed one.
DW4
Ah.
was the Gaupura, Lordship, and nothing is here about the Gaupura.
Yes, Mr.
Even
Pine,
some-
if it is not, then it's
He-
effective.
Even sir, exhibit
An
11
opinion
is the
rendered
passport,
without
Lordship.
considering all the relevant documents are defective. And Mr. Though it has been, the Lana Council for the petitioner submits that though the Gaumbura of the,
Gaupura of his birth village, Lordship, where he was.
which
born.
village, which
It's
village?
Medhipara, Lordship,
Medipara was examined as
Udalguri.
DW,
in Udalguri district.
in DW as DW
DW4, Lordship.
4. His evidence was not at all considered by the learned tribunal. We have also gone through, having perused the impugn order dated 17/6/2022. We have also noted that though the learned tribunal has referred to the evidence of Abul Hussain, DW2, the proceeding is DW1, Abul Hussain, his brother is DW2, and another brother Ali Hussain is DW3. There is no reference to the evidence of DW4. Is there DW? Yes, Mr. Pine.
My lord, DW4, whether it is examined or not, that is not clear, my lord.
Why have you stated DW4 has been examined? Have you stated in your petition?
Yes, Lordship, I have stated. Lordship.
Where is it? In. Where have you stated DW4 was not examined?
Gaupura's certificate I have exhibited. Lordship.
Para 13.
Yes. 13,
Para 13 is Mr. Pine.
yes, Lordship. Next we said he examined the Gaupura of Medhipara as DW4 to prove the contents of the certificate.
So we have the view that if any opinion is rendered without considering all the evidence on record, it may be a ground for challenging the said. In the present case, we have not noticed the reference to the evidence of DW4. Under circumstances, the petitioner has been able to make out a prima facie case for grant of bail. Accordingly, the petitioner who has been detained in terms of the aforesaid impugn order dated
Dated is
said 17/6/2022 shall be released on bail subject to punishment beyond bail bond of 5,000, which relative like amount to the SP border
SP border Dorong. Lordship.
Dorang, to the satisfaction SP border Dorang. He will capture fingerprints, then the biometrics of the iris. The petitioner also shall not leave the leave the district without informing the SP border Dorang. Let the records be requisition.
I have laid.
For supplementary list, motion, item number 13.
Nur Islam,
Lordship, may it please your Lordship.
yes. Yes,
Your Lordship, here
Ah.
the father of the petitioner's name appeared from the voter list of 1961.
so we'll issue notice.
Yes, your Lordship, his name also appeared along with his parents.
Okay, we'll issue notice, yes. And Mr. Narayan Council for the petitioner, issue notice in 4 weeks. पहले भी same thing है, issue notice है, they will receive issue notice and so. Mr. Pine accept notice on behalf of respondent number 2 and 5, no, 2 and 5 perhaps,
Yes.
2 and 6. 2 and 6, huh?
2 and 6.
2 and 6. LDB for 1 and
1 and 4, my lord.
1 and 4. U Das
4, 5.
5,
Yeah.
2 and 5. You, huh? Acha, you, Ali, okay, Ali for election commission. Okay, yes. Let the records be called for. You have been detained?
No,
No.
Your Lordship, I'm outside.
Huh?
I'm outside, Your Lordship.
They will submitted the petitioner has not been detained on the stand of the MP noted dated 21/12/2021 passed the Lana Tribunal first Sonit Cohen, so that is so the petitioner will be allowed to remain on bail subject to furnishing a bond of rupees 5,000. Same.
Right.
Item number 14,
SP border? SP border, Sonit, yes, next.
14.
Hormuz,
May I please, Your Lordship? The petitioner's grandfather, father, all are the name appears in
will
the
issue notice,
1950
will issue notice, and Mr.
Lordship, now I am in detention camp. Lordship, page number 62, Lordship. I have not given opportunity to file any evidence on affidavit. Page number 62, Lordship.
OP is absent today.
Lordship,
Petitioner grant time of filing evidence should have been present himself or by council, however, bond rejected. Final order.
let's say,
Mr.
after that, page number 64, Lordship. Without giving a opportunity to file evidence on affidavit, I have been sent to jail, Lordship.
What is the impugned order? What is the
If you
order?
know page number, Lordship, 66,
Hmm.
annex 20, Lordship.
Yes, Mr. Payne, what to do?
My lord, in this case, this is seems to be, my lord, the.
All orders are annexed, Lordship.
My lord, the.
If the lawyer was present on the last day, he said that the lawyer himself, he himself has to come.
Born and brought up in India.
What is the-
citizen of India.
Was any evidence laid also? Did you file a
Not-
written
not given
statement?
Any opportunity, Lordship.
Procedural petitioner being heard. Tell us what to do quickly, Mr. Payne.
My lord, may tendencies. Page
Immediately
66,
pass this
my lord,
order,
there are
Huh?
two, my lord.
Hmm?
Page 66 is the opinion, my lord.
Yes,
Was absent on 26/7/2022 and 30/7/2022. To the step, but he
Correct,
was
correct.
paid to file his evidence more.
I have been detention, Lordship, 5/8/2022.
Filed on 30/7/2022 was rejected.
yes.
3 dates were given, my lord.
Correct. We have noted that, but you think that by default he should be sent? He should be perhaps given an opportunity. And he has come here.
The problem is that, my lord, the purpose of this, my lord, the act itself.
Correct. That is true, but then
And the
these
legislation has.
are very important right of a citizen, no? So as far as possible, it should be decided on unless absolute,
Well, but,
negligence. It's not that he did not appear, he appeared,
Yes,
Lord,
he has
counsel
engaged a
appeared
council also.
Lordship.
Maybe there are some reasons. Proceed himself, such prayers should have been made by Proceed himself or by council. The council was there.
Lordship.
Council for a prayer to grant few more time for filing evidence of OP. Yes,
You-
tell us what to do. Tell us, Mr. Pine.
Previously, he was on bail, Lordship.
my lord, if the lordship, my lord, please to remand the matter even on, my lord, only my prayer will be, my lord, because they are playing with the tribunals, my lord. In fact, they are not
They
interested.
should be sure. Yes, absolutely. They must be absolutely sincere to that. Yes, they should not.
So that aspect may be considered, my lord.
Okay, so will that without fail you appear and file the written statement at the earliest. And they must file. Have you filed a written statement?
International already filed. Lordship.
Already
After
filed.
that, fixed for filing evidence on the affidavit.
So you
Was
file
unable
it.
to-
So
Lordship,
when can you file it? Tell us.
Lordship, order,
You tell us when can you file the affidavit? When can you file the evidence?
when and wherever, Lordship.
You tell us. We don't know what is your position. You tell us how many days you will require. We then will record your statement that you will file this evidence.
After 15 days.
15
or
days?
1 week, Lordship.
Okay. Yes, Mr. 15 then
With
yes.
some cost, my lord.
Huh?
With some cost.
What is the point of putting cost in? I
All
don't know.
recorders here, Lordship.
These
My
are-
lord, the
Okay, 500 rupees. Yes, Mr.
Here, Lordship.
Chair Lana Council for the petitioner, House Lana Council for the state. To stop. In this petition, petitioner has challenged the ex-party order dated. No.
Type it.
No. The order dated. The order dated
5/8.
5/8/2022, by which the petitioner was declared a foreigner who had entered into territory of Assam, Assam after 25th March 1971 without any valid document. The Learned Tribunal, it is the case of the petitioner that that after receipt of the summons from the tribunal, the petitioner appeared before a tribunal, filed her written statement. Unfortunately, she could not file the evidence by affidavit. Granted on the dates granted by the learned tribunal. And on the last occasion, when the matter was put up on 30/7/2022, the petitioners, the counsel for the petitioner prayed for granting few more days for filing the evidence. However, the learned tribunal rejected it on the ground that the prayer should have been made by the proceedee himself or herself,
Himself.
and not by his counsel.
Lordship.
And such petition is not borne by affidavit. Full stop. We have also noted the impugn order dated 5/8/2022 passed by the learned foreigners tribunal Johar in so and so what we have also noted, as mentioned para 2 thereof, that the petitioner had remained absent on 26/7/2022 and 30/7/2022 without taking steps. Learned counsel for the Mr. Pine, learned counsel for the state submits that the proceedings appear to be taking casually the proceedings the proceeding before tribunal, and as such he himself has to be blamed for the passing of the said order as he failed to file the evidence by affidavit when permitted by a tribunal. Full stop. Next paragraph. We also mindful of the fact that when the proceeding appears for tribunal, he must act with utmost diligence and promptness in filing necessary documents or affidavit, as the case may be. However, in the present case, what we have noted is that he remained absent only on 26/7/2022 and 30/7/2022. Moreover, the learned tribunal rejected the prayer of the petitioner to file to seeking time on the ground that the prayer was made by the counsel, not by the petitioner himself, which we find to be very harsh, inasmuch as the counsel was authorized to appear on behalf of the proceeding, be there as it may. Since the opinion was rendered without considering the materials on and not on merit, but by a default, and since the right of a person and the citizenship right is an important right, we view that ordinarily it should be decided on merit. In the present case, considering the circumstances which have been revealed as per the record and as well as the order dated, impugn order dated 5/8/2022, we have the view that the petitioner may be afforded another opportunity to appear before tribunal to file his evidence, documents, etc. Accordingly, we allowed this petition by setting aside the impugn opinion dated 5/8/2022 passed by the learned foreigners tribunal Jorat in case number FT/SBR/07, page 66. Petitioner accordingly will file his affidavit in chief within 1 month from today. Failing which the tribunal will be at liberty to proceed against him in accordance with law. Full stop. It has been submitted by learned counsel for the petitioner. The petitioner has been detained on the strength of the impugn order dated 5/8/2022. If that is so, he may be released on bail so as to prosecute his case, so as to enable him to appear before the tribunal and tribunal to prosecute his case claim before the tribunal. Full stop. Accordingly, he shall be released on bail on furnishing a bail bond of ₹5,000 with security like amount to the satisfaction of the superintendent of police, border, Jorhat, Sibsagar. Full stop. The SP border will also capture the fingerprints and the biometrics of the iris of the petitioner. Full stop. The petitioner also will not leave the district, Sibsagar district.
And Juhat
No,
district, the case registered in Sibsagar, subsequently transferred to Juhat. Now this order directed to the SP border Sibsagar for detention.
Okay. Okay. He also mentioned that since the petitioner is ordinarily resident of district of Nagaon, he shall inform the SP border Nagaon before he leaves the district, and the SP border Nagaon shall remain in communication with the SP border Jorat for the purpose of FC border Sibsagar for the purpose of this proceeding. With the above observation, the present petition is allowed.
Highly obliged.
Item number 15.
May I clear lordship? Lordships, expert your lordship, I mean custody lordships.
Ex parte order, why? Why?
You also kindly see the order of the current tribunal lordships, page 31 lordships. This is the order that I appeared,
OP present in steps, and so OP is
Yes.
present today.
lordships.
OP absent without any step, there is no reason being assigned, filed hence.
Only two that I could not appear lordships. As I live in Dorang district and cases pending before the Durham district lordships.
Okay,
And
yes, yes, yes.
Same lordships.
Okay. And Mr.
M. Hawk lordship.
I have Lana counsel for the petitioner, also Ms. Verma, Lana counsel, Lana standing counsel for the FT. और also सबका नाम लिखो, पहले भी सबका नाम लिखो. Considering the nature of the case, we are of the view that present petition can be disposed of at this stage without issuing any formal notice to the respondents. Post of next para. The petitioner has challenged the ex parte order dated
29/7 lordships.
29/7/2022 passed by Lana Foreign Tribunal Johra in the FT case number case 39.
Lordship.
It has been submitted by Lana counsel for the petitioner that the petitioner, after receiving summons from the tribunal, had appeared before the tribunal and filed his written statement.
No, lordship, I could not tell.
Okay, someone had appeared for the tribunal and a short time for filing written statement. Full stop. It has been submitted by Lana counsel for the petitioner that the petitioner could not appear for the tribunal on two occasions, namely on
All
Seven?
lordship, 7/7,
that could not file the
18/7.
written statement on two occasions, namely on 7/7/2022 and
18/7.
18/7/2022. However, the learned tribunal proceeded the matter ex parte without this written written statement of the petitioner. Full stop. It has been submitted as the inability of the petitioner to file written statement was because as he was seeking more time to collect relevant documents.
Lordship.
And as such, it cannot be said that there was undue negligence on the part of the petitioner to do so. We have also gone through the orders passed by the Learned Tribunal in this regard. We also noted that the petitioner could not file the written statement on two occasions on 7/7/2022 as well as on 18/7/2022 as spread by the petitioner. Full stop. Ms. Verma, however, submits that the failure to file a written statement by the petitioner is because of the fault, not on account of any other person, or no blame could be put to the tribunal.
My submission would be that it's a long pending case of 2003.
Moreover, this is a long pending case of 2003, and as such, the petitioner ought to have collected all the relevant documents, and as such, such delay is merely to prolong the proceeding. Full stop. We have having heard the Lana counsel for the petitioner as well as for the state. We also view that the petitioner must take all prompt steps to file the necessary written statement or the evidence. However, we also view that it will be desirable that before a person is declared a foreigner, before the tribunal decides declares a person a foreigner, it should ordinarily be on a basis of based on merit of the case, not on default. In the present case, there was no consideration on merit of the case, but the decision opinion was rendered declaring the petitioner to be a foreigner on default, on failure of him to file the written statement. Considering the importance and significance of the right of citizenship, we are inclined to allow this petition however, on the condition that the petitioner shall take prompt steps for filing of the written statement and also the relevant documents he may rely upon to support his claim that he is Indian. Accordingly, after hearing the parties, we allow this petition by setting aside the impugned ex parte order dated
29/7.
impugned, not ex parte, impugned order dated 29/7/2022. However, the petitioner will immediately file the written statement within a period of 1 month from today. Failing which the tribunal will be at liberty to pass appropriate order in this regard. Full stop. Next para. You are in jail.
Yes, lordship.
They have been submitted that the petitioner has been detained on the strength of the order dated 29/7/2022 as full stop. In order to enable the petitioner to appear before the tribunal to prosecute his claim before the tribunal that he is Indian, he may be released on bail, subject to furnishing a bail bond of ₹5,000 amount, full stop, to the satisfaction of the SP border.
Sipsagar Lordship.
Sipsagar.
Case is
Sipsagar.
pending to have Lordship.
Sipsagar. So it's Boris Sipsagar. Also, the SP Boris Sipsagar also will capture the fingerprints and the biometrics of the iris of the petitioner. So the petitioner also will not leave the district of Sipsagar.
Lordship.
Sipsagar without informing the SP border Sipsagar in that regard. Full stop. The Sipsagar SP border Sipsagar will remain in communication with the SP border Jorhat. Before which jurisdiction the tribunal Jorhat, where the foreigners tribunal is located.
Lordships.
Full stop. Next para. Accordingly, the petitioner will appear will file the written statement within 1 month of the release. Will file the written statement within 1 month of the release from detention, and on filing such written statement, the learned tribunal will proceed with the matter and pass a fresh opinion in this regard. Full stop. With the above observation, presentation stands allowed. What is this IA? IA disposed of in terms of the past by the court in WPC number so and so.
Lordship.
Nurul Haq.
Item number 16.
My lord, may
You
kindly
issue notice. Call for the records.
Lordship may kindly call for the records, but I have been taken in custody by police on 38/2022 pursuant to the order, my lord.
So what we done?
My lord, Lordship may kindly grant me bail to the directing the SP Dorang to release me on bail, because we have the documents of 1964 and 66, 70. So all these documents, they are learned tribunal said they are not trustworthy, and linkage is not proved, whereas in voter list my father's name is there. So kindly grant me the privilege of bail and record.
What are the documents? Let us see.
Impugn order, page 72. Gavra's certificate, exhibit 1, that was not believed. And that, my lord, linkage, it is saying long not proved, whereas linkage is there in voter list, my father's name is there.
Show you what is father's list, voter list. Show the voter list of father.
Father's, actually, my father died during my childhood. My grandfather's name may be seen as page 17, my lord. Page 17.
Page 17 is the affidavit.
17. 18, page 18, my lord.
What is your grandfather's name?
Abdul Ghani and
Abdul
Gulandi
Ghani.
Hasan. And my petitioner's parents, page 20 may be seen. This is the voter list of 1966, my lord, 61.
Page.
Page 20. My father is Abdul Hassan and mother is Nurjahan.
See,
Page 20. It is the voter
your
list of
in page 18. Page 18 is Abdul Ghani. Who is Abdul Ghani?
Abdul Ghani is my grandfather.
Your grandfather. And grandfather is the son of Abdul Ghani is the son of?
Abdul Ghani
Is the
is
son
the
of
son of Jainuddin.
Jainuddin. And in page 20, what is your name?
My name is Nurul. No, my name appears in the voter list, other letter voter list, my lord.
No, in page 21.
No, that is not my name.
Okay.
My name may be seen page 43, my lord.
Page 43. And what is this page 20? The same. Abdul Ghani or Abdul Hassan?
Abdul Hassan is my father. There are some anomalies in name that we have clarified.
No.
Now, Lordship,
You
may
say your
kindly-
father has died.
Father has died long back, my lord. Actually, that is not on record. And he has been taken in custody. That is why I could not mention. But
Huh?
thing is this, my lord. He
You
has also,
see, Jainuddin, see, your grandfather's father also Jainuddin, and your father's father also Jainuddin.
no, that is
How-
wrongly written. That is wrongly written. But other documents, Lordship, may kindly see. Registered cell list, page 23.
Hmm?
Registered cell list, page 23. That is
Abdul Ghani Sardar, son of Jayan Sardar.
she is my grandfather.
Then, my lord,
Okay,
Gunduri,
we'll consider, yes. Hard Mr.
Gunduri
Lan-
page 28, my lord.
Okay,
That
hard
is the
Mr. Lane,
NRC.
counsel for the petitioner.
Interim
Call-
on the next date.
Okay, next, let the record come, yes. Hard Mr. Lane, counsel for the issue notice for sub ka naam likho. So and so receives, huh? Let the record be called to order. Interim will be considered on the next date.
Bill
on-
can be considered because,
The bill will be
because
considered
I have the documents, my lord. Actually.
on
Ladder
27.
Tribunal- Ladder
27.
Tribunal asked me not to reduce further evidence. That I have stated. Tribunal restrained me from reducing more
It has
evidence.
been submitted by Lane Council for
Page
the
13
petitioner
kindly
that
see,
the
page
tribunal had prevented the petitioner from adducing further additional affidavit.
Page 13 can
In
you
view
see?
of the above, we will consider aspect on the next day, Tariq Divo 26, 27,
2017.
2710. Yes, we'll consider. Application of bail will be considered on that day. Let the state file objection. Yes, next.
Item number 17.
Yes, Mazabar will issue notice.
My lord, this is my lord, issue has been settled by the small court. Here, my lord,
About-
issue involved, my lord, digitally signed voter list is disregard. Page, my lord,
Page.
63, my lord.
Okay. Where is it, para number?
Last para, my lord, page
Yes.
63.
The
This
submitted voter list are
voter-
verified OP from the election officer doing the receipt from election when obtaining voter, but the voters are all electronic server. So because of that ground, that can be a ground. Yes.
And this has been settled by the small court.
Anyway, we'll call for the record.
Examine it.
Closed.
Okay. And Mr. Lane counsel for the petitioner, also Lane counsel for the issue notice number 4 weeks, Ms. Venture sub accept. Call for the records. The petitioner has challenged the impugn order on various grounds, including on the ground that the Lane Tribunal did not take into did not consider the electoral list, electoral rolls submitted by the petitioner on the ground that these are digitally
Digitally
signed and not admissible. Full stop. Full stop. Full stop. We'll examine the issue. You are out or inside?
Out.
It has been submitted. The petitioner has not yet been detained on the strength of the impugn dated page 60, 22. Same. SP border
Dhubri, my lord.
Dubri. Fingerprint, iris, everything. First.
Obliged.
Item number 18.
May I please, lordship, the impugn order may be seen page 123.
Yes.
I have adduced as many as 4 witnesses,
Yes.
including my mother and DW2.
Let us see your mother's evidence.
Mother's evidence may be
Evidence?
seen page 100.
100. Yes. This is a Amina Khatun.
Yes.
And cross-examination of your mother.
Cross-examination is not there, madam.
What do you mean by not there?
No cross was there.
This is there, page 111. My name is Amela Begum. My husband name is Khas Mahmood. My daughter, I don't know the age of my.
Letter day.
I have 2 sons. My name is my mother died. I don't know how many years. My God, there are no lines of my husband. So okay, we'll issue notice.
Notice, lordship.
Yes, I may be granted bail, madam.
You are on jail.
No.
Okay. And Mr. Lane counsel position call sub likho. So receipt.
SP Borpeta.
Is submitted the petitioner has not been detained on the strength of the impugn opinion dated. Page number.
Page number 123. Dated 31/8/22.
Impugn opinion dated 31/8/22 passed by the Lane FT 8 Borpeta in FT case number 26077. If this is the petitioner may not be retained, but may be allowed to remain on bail on punishment bail bond of so. SP border?
Borpeta.
Same, no? I
All
do
right.
fingerprints. Yes, next.
Item number 19.
Yes,
This is an expertise opinion of the learned tribunal.
expertise. Why expertise?
Because only 2 dates I have missed out due to non-appearance of my engaged counsel at that point of time.
Yes, Verma.
What you will examine, lordship. What you will examine,
So,
the
my
matter. I
lord,
didn't get time to go through the opinion.
In the meantime, my lord, one of his brother against whom a proceeding was initiated, he has been declared as second stem. So kindly,
Yes,
Lordship.
yes,
second
yes.
stem,
Huh?
Annexer 5,
Declare as
in second stem, my lords.
second.
Between 66 to 71 stem by the
Oh,
learned
that's-
tribunal. So my
They
lord,
have come from Bangladesh.
Yes.
They have Bangladesh, but then they will come. Anyway, we'll examine anyway. We'll call to
so
record.
it would be better to remand this because unnecessarily it is for a long time.
16, ex parte order has been passed because they have not been
18.
submitting documents and filing their WS
No,
document.
no, I have been.
What is the final order? What is the MP notice?
Whatever find 30
2020 Lordship. On
20.
3
During
April
lockdown time.
2020. And on the date
and
of
it's-
argument was 22/10/2020. They didn't come up with their documents, Lordship.
My lord, a party portion of the order, page lordship,
Originally case was forwarded.
35.
Notice was issued along with engaged counsel, but OP two may adjourn
Only
without
two
any question. Finally was absent and hence was decided in view of my opinion, namely stream.
Only
No,
two.
which is the order you are challenging in this petition?
I am challenging input on annexer 4. Lordship will find the input party portion at page 31.
Just, final order, huh?
Yes.
But this 2018,
2008,
Yes,
Your Lordship.
but the
original discuss
circumstances.
forwarded, perusal order. 2018, madam, 2018, 19, 20, 21, 22, 4 years, you didn't do anything, he's here in India, what you have been doing?
No,
He's allowed to roam around,
there is a fault.
why don't you deport him?
We cannot deport him, Lordship.
Why?
Because
He has been declared a foreigner since 2018, what you have been doing? Originally case was forwarded, so and so, video OP is not a illegal immigrant.
I have also.
There is
filed
the
a
case record,
evidence.
notice from OP issued, so and so, return being duly served. Actually, opiate, so and so, along with so and so, why, so and so, so and so. I have care of parents. Presume to regularly burden of proving one's lies on the so and so. Anyway, call for the records interim. In the meantime, it shall not be
My lord, it will be mid the answer justice to dispose of this matter.
Next.
I mean,
Item number 20,
shall not be deported or detained. Subject appear before the SP border so and so, so and so.
obliged.
Yes.
May it be lost, my lord. Here, my lord, the petitioner is totally illiterate lady, my lord. She had engaged two lawyers twice, my lord, but doesn't want to blame the lawyers also because she lives in such a place, my lord, there is no communication as such. And she doesn't have the mobile number, any communication.
So what do you want? What is the impugn order?
Impugn order is annexed is page 31, my lord. So the lawyers were engaged twice. WS was not filed. So it is.
Yes,
Order.
Verma, what to do? Tell us, ex parte
Lordship,
order.
we have also noticed, Lordship will examine this matters of 2011, Lordship. Though we have not detained her, that is also correct. But from now onward, we'll take steps, Lordship.
Order is
We
87
issue notice at
The
this-
case will revive
this point,
on a
notice will
notice
go,
should have
Lordship.
has been duly served as per notice server.
Earlier notice could not be
The
served, my
record
lord.
display after receiving notice the proceeding Manware being appeared tribunal on 9/2/22 along with her concerned advocate Sadiq and filed a bail petition. The petitioner was released on bail. Next day was fixed on 28/2 for filing written statement. Several have been granted filing, but has not taken a step till on 7/5. The consequences Meenakshi Kumar filed a petition praying for another date. Thereafter, several have been granted and written, but neither proceed. But you have been granted several times. That's why it was proceeded ex parte.
From 2000.
You have been granted several
Yes,
times.
my lawyer saying, but what the problem is, my lord, I have explained in paragraph 15 to 19.
Yes,
Paragraph 15 to 19.
yes.
Because she stayed in my lord, on the shore of Brahmaputra, the village. She does not have the mobile number or any communication. A lawyer also she does not blame because she has engaged the lawyer twice. Perhaps they could not contact her. Ultimately, lastly, she met one ex-MLA. Imdad, he is also advocate in this court under me, practicing under me. So he guided her to come to High Court, my lord, to the illiterate. But otherwise, her document is there in 1951. Her father was 8 years old. Annexer C, NRC, 951 NRC.
But you have filed all these documents with the High Court, but you cannot file in the
No,
before
I
the
will
tribunal.
file. This time, well, because this time a trustable man a reliable man, he says, God.
You have got a connectivity now, you have changed the mobile number or what?
No, there is no mobile. She doesn't have the mobile at all.
Then how will you ensure that you will appear again?
No,
in
no.
time?
Now, my lord, the lawyer who is practicing under me is
Huh.
also XML of that area. So he has undertaken to
Lordship,
see that.
submission would still be.
So, my lordship may quash the order and
Lordship.
allow her a 1 month time to appear and file WS. That is best work. Otherwise, even in dream, my lord, she cannot declare as foreigner because 1951 NRC, her father's name is there, grandfather, grandmother.
Let's see, let us see your name, let us see.
My lord, first go to page 18.
What is this
19.
page 18? Who is your
NRC
grandfather?
Grandfather is my lord. Sarjimuddin is grandfather. Rahira Khatun is grandmother. And Khairuddin
Azimuddin, huh? That is the
is
grandfather.
father.
And
He was-
which year? This is 1951.
951 years.
Then?
He was only 8 years. Khairuddin 8 years.
Yes, then?
Then my lord, this is the certificate which is not very
Page
legible.
20.
Then my lord, cycle license, page
What is,
23.
page 20, what is this? This is
23,
page 18 in 1951. And this page 20 is which year?
1965.
1965.
Yes, of her father.
Father. What was the name of father?
Khairuddin.
Huh?
Khairuddin.
Khairuddin, son of Sajimuddin.
Yes.
Hmm.
Yes.
Voter Talika.
Yes.
Voter Talika of what?
Because
Oh, which voter Talika? Voter Talika of which this?
Voter Talika is my 71, 1971. I have the original one also.
No, this voter Talika of which vote?
Voter
Panchayat,
Talika,
Panchayat, this Panchayat, Jila Parishad, what? Parliamentary, nothing is mentioned. Voter Talika.
My lord?
Translated copies are not complete, lordship.
No, page 21.
Page 21.
Page 21, voter talika of which relating to what? Gram Panchayat ki what?
No, assembly, assembly.
Assembly. We don't know. Is it mentioned anywhere?
It's not
My
a
lord,
certified
yes,
copy,
voter
lordship. It's
Talika.
just a document.
Years on 1971. 1971.
Where is it written?
My
111971.
lord, page 21 on the extreme right.
1119.
71.
One.
71 handwritten.
Then this is in this case. What is the name, Mr. Khairuddin Ahmed,
Yes, Khairuddin.
son of
Sarjimuddin.
Sajimuddin.
And Rabia Khatun is
House number. Ki Jaga. What is the name of the place? 1971. Which place?
1971, my lord. House number 20, name of the Shensu. Voter Talika. It is now Boisa, my lord. Now Boisa Assembly Constituency.
And this page 23, Khairuddin,
Yes.
1951, Khairuddin.
This is my lord, 1965. This is
Now, what is this? 1960
license fees for purchase of cycle. In
Cycle.
those days, there used to be license.
Khairuddin Ahmed,
Yes.
resident of
Is this Bangalmara?
Bongalmara,
Bangalmara, Laluk. Laluk PS is
Laluk
PS,
Hausa.
yes.
Bangalmara.
Yes.
Hmm.
And NRC also, my lord, final. It has come in 2019.
24 is
24 is NRC, final NRC.
NRC of
2019.
then this. What is this 27? Anwara Srimati
This is
Anwara
notice.
Kom.
No, notice by FT.
Anwara Kom.
Yes.
Kom.
Anwara Begum. My
Anwara
name.
Begum. Okay.
Yes. My name, I was issued the notice by FT. It is second time. First notice they could not serve, my lord, because they could not reach my location, being remote. This is second notice. It is reflected in the order also, my lord. Thank you.
And what is the certificate? Page 16?
Page, my lord,
Page 16,
16 fathers, my lord,
Khairuddin Ahmed.
yes, school certificate of 1954. Up to class, he passed class 3.
Khairuddin Ahmed.
Yes.
And who is this? Yaqub Ali? Yaqub Ali.
Yaqub is my husband. Husband, marriage certificate also I have next, my lord. Next A.
Marriage certificate.
Yes. Yaqub Ali. The photograph is there, my lord. The husband wife. 1985.
Then let him go and prove there's all these documents.
Lordship, my friend's contention that the proceeding could not be contacted, Lordship, I draw Lordship's attention to page 31 of the opinion, Lordship. Second paragraph, Lordship, the case has been revived again on 2022 and notice issued. First time the notice was returned unserved.
Likho, notice likho, notice records, in the not
Lord.
reported.
Lordship, she has already appeared and she's on bail, Lordship.
She's on bail. Okay,
already
let
on
her
bail.
remain on bail. It has been submitted that, are you on bail or jail?
Bill.
She's already
She will
on
be,
bail.
she will be allowed to remain on bail.
Yes.
22 are on bail. However, she will appear for the SP border,
Lakhimpur.
Lakhimpur. Sab baki same likho. Will examine after issue of notice.
Notice of an issue, my lord.
Yes, you should notice sab likho. This is yes.
Apply, my lord.
For orders, daily list, item number 4.
Item number 4. What is
Yes,
this?
Lord.
Marvel? What-
There, my objection is also there on record.
Lordship,
Yes, tell.
Lordship, in this case, Lordship, already paperwork prepared, Lordship.
Yes,
And
tell.
Lordship, at this stage, Lordship may pick for hearing, Lordship.
Okay, har Mr.
I use the Lordship.
And counsel for the petition submits that the matter is ready for hearing according to the matter list for hearing in usual course. Yes, next.
Lordship.
What about this I?
Let it be
Lordship, I am at the
pending then.
pending, Lordship.
Okay,
If Lordship hearing not take place, Lordship, then I will be considered, Lordship.
okay. I am likho. He says he may be allowed to argue on this on a letter at a later stage. Yes. Yes,
Item-
yes,
Item number 5.
yes. Item number 5.
5, Mr. Anjedas.
Chikoram Gowla.
Yes, a paper book is not ready. LCR
Not
is here.
ready.
Not ready. LCR is here. Amicus, I know him, I can tell you. He somehow must have missed.
Since the records have been received, let the paper book be prepared.
Lordship.
Thereafter the matter be listed.
Ah.
Then
Item number 7.
7 is I is there, I'll file my objection. I have not filed it as
Yes.
yet.
Lordships, in this matter, Lordships, our IA is pending, Lordships, for consideration, Lordships. My learned friend,
I've already prepared it. I'll file it immediately on the DOPT.
Lordships,
Okay.
Lordships will fix it after vacation immediately, madam.
okay, Miss Miss Jahan prays for some time to file objection in IA, in the IA, right? Objection list accordingly after vacation. Take it.
Service is complete.
7-11.
Lordships, in
Sir.
the main case, Lordships, probably the LCR has not been received, Lord.
LCR has not been received.
No, it's not there, but service is
Okay.
complete.
But what about the informant? Informant has
service
been,
Service is
complete.
complete, Lordships, there,
informant has been also
Ah.
notified.
Yes.
And who is appearing for the informant?
Lordships, their name is shown in the cause list, madam.
Oh,
Yes.
I see. Okay, then. Await LCR.
Oh, yes.
Await LCR. And in the main, in the IA, list Ms. Jahan prays for some time to file objection. List accordingly on so and so. Okay.
Lordships, can it be fixed in the first week of November, madam?
Oh,
7-11.
yes, yes.
Sir. Obliged, madam.
Item number 8.
Humayun Kabir.
This one I file my objection. Yes. Hold on.
Yes,
Lordship, in this matter, they have filed objection, Lordship.
they have filed.
Filed, Lordship. My
It's on
own
record.
record, Lordship.
So tell us what do you want?
I am not selling on a good position, Lordship, with this IA, Lordship. So
Tell us what do you want?
otherwise,
Matter may be fixed for hearing after preparation of a paper.
He's,
MK Hussain.
her,
MK Hussain.
MK Usalani Council, who said he's not pressing the IA. Accordingly, same is closed as not pressed. However, is spread, liberty is granted to file the IA at appropriate stage of the appeal. Full stop. Yeah. In the IA, records have been received or what? In the main, records, huh?
Paper
Receipt.
is
Paper also prepared, huh?
No,
Not
no.
ready. Okay.
paper.
Since the records have been received, let paperwork be prepared and thereafter the matter be listed for hearing in usual course. Yes, next.
Item number 10,
Ismail Ali, what is this? 10.
Right,
IA for what?
Your lordship, an order has been passed to your lordship.
Yes.
Very honorable court, your lordship. Your lordship may go on page 12 of the IA.
Page 12 of the IA.
Lordship.
What is that?
Your lordship, here I was asked to appear before the superintendent of police, your lordship.
Yes.
On before 22/9/2022.
Ah.
And your lordship, but below, if your lordship goes at the last line of this page, item page 12.
Yes.
Since the petitioner did not state as to whether he has been taken into custody or not, prayer made by him regarding his bail is declined. So your lordship, when my prayer for bail is declined, it becomes impossible for me to appear. Your lordship, then I have taken a ground, your lordship may move on to page 7, your lordship. Page 7. Because your lordship,
Yes.
para 3, that the application begs to state that he has already mentioned in para 14, page number 15 of the writ petition, so and so that the applicant is not yet been arrested in connection with the instant case. So your lordship, it has been stated that I have not mentioned whether I am outside or inside, your lordship, but I have mentioned in para of
Yes,
page
who is
15
for
of
the,
para
yes,
14, your
government,
lordship.
government. Yes, yes.
In the main petition I have mentioned, your lordship.
G Sharma, call them, call them, call them. Just call them. Anyone from the FT? Yes, G Sharma, this, have you seen the application?
Yes, yes, Lord.
What to do? Tell us.
Yes, Lord.
And the main petition para number?
Para number of page 15, para 14.
No, no, in the main petition.
Yes, your
petition.
lordship, page 15, para 14.
Page 15,
15, 15,
15.
para 14.
Yes, he has already stated in para 14.
Yes, yes, Lord.
So we shall make some order change, modify.
Yes.
Okay. And Mr. I, Hussain Lane, counsel for the applicant. The present application has been filed for modification of the order dated 7/9/2022 passed by this court in WPC number 5818/2022. Wherein this court made an observation that since the petitioner did not state as to whether he has been taken into custody or not, prayer made by him regarding his bail is declined. Lane counsel for the petitioner submits that the said observation has been made by though the said observation made, it is not the petitioner had clearly mentioned in his petition in para number 14 that he has not yet been arrested or detained in connection with said case. The said para 14 is reproduced herein below. In view of the above, we are of the view that that since the petitioner had categorically mentioned in para 14 of the petition that he has not yet been detained or arrested or detained in connection with said case, the observation made by this court, the order passed by this court that since the petitioner did not state as to whether he has been taken into custody or not, prayer made by him regarding bail is declined is modified by granting him bail bail, by granting him bail, the petitioner will accordingly appear for the SP, Superintendent SP Border, Sonitpur, within 15 days, 15 days. We receive a copy of this order and will and furnish a bail bond of rupees 5,000 which security will like amount to the satisfaction of the SP Border, Sonitpur, Tezpur, fingerprints, Irish, all other conditions.
Obliged, Your Lordship.
It is IA accordingly allowed. उसके पहले को had also Mr. G. Sharma Lane counsel for the petition who also has stated that it has been mentioned in paragraph 14 of the writ petition that he had not been arrested or detained in connection with said case.
Item number 11.
Yes, what is this?
Writ appeal which has been listed along with an application for continuation of delay of 179 days.
Condonation of delay. So will we have to issue notice, isn't it? Condonation of
So,
delay.
yes, but I also wanted to file an additional
You
affidavit.
file an additional affidavit. Yes. And Mr.
NL Ganapati,
And Ganapati Lana counsel for the applicant, the present application has been filed for continuing a delay of 179
179.
day and filing the writ appeal against the order dated
7/2/22
7/2/2022 in
WPC number
WPC number
3784 of 2020.
issue notice be issued. Issue notice. Hiteshwar Sharma, they are all private. You have to take steps, perhaps, huh?
3 and 4, 2 and 3 are official response.
The deputy commissioner. Okay. Petitioner takes steps upon response number 1 and 2 by Resa post with AD. Ms. Udas accept Lanet standing counsel for the state accept notice on response number 3. Mr. Ganapati submits that he would like to file an additional affidavit in this application. He is allowed to do so. Which a copy of which will be furnished to the a copy will furnish to Ms. For the response number 3 and also will be sent along with the notice to be served upon response 1 and 2. Is it okay?
But your lordship will not issue notice on the writ appeal right now. It's only on the.
Obviously, we cannot issue. We are not even looking at the writ appeal because we have not yet condoned the delay.
Very.
Once it is condoned, then we'll see.
Could it be fixed, my lord? Could a date be fixed?
Release the matter again on November.
It'll be October, my lord.
October.
21st October. 21st October, if it is possible.
21st October.
There is a
Is
reason
it-
because there is a connected writ petition which is listed before a learned single judge on 1st of November.
Okay.
So if this is taken up earlier, then
Okay. But then notice has to be served.
we will serve it.
Okay. 21st of October. List on 21st of October.
Great.
Okay. Yes. Yes. Just kindly give extra copies the government
will
would
do all
like,
that.
because they
We
will
will
also
certainly
retain
do.
one copy and furnish to another one.
Certainly,
Extra copies be furnished to Ms. Das, Lana Council for the response number 3.
certainly. Great.
Daily list for hearing, item number 21.
What is this? 21. Yes.
I pray for some meeting to the lordship, but my opinion is on late from court number 1, lordship.
Yes.
But after vacation, lordship.
You're good friends, so good friends, no? You're all. Huh? She wants
exercise, lordship.
correct. But then the council is on lake. When this is the only matter left, perhaps.
Yes,
Yes, sir.
last one.
Lordship raised that point, lordship, regarding this case diary on the section of
Have you done some work also on that?
Yes. I got something,
Give, it will be good. Let us see that.
some more thing.
You do that because these are not yet been explored. I don't know. At least not argued before this court. So if you have in the context of this UAP Act, no? Where is the para number?
Pair number 14. Yeah, minor comment.
No, correct. There is no dispute about it. The question is at the time of consideration of bail application.
That is why I found one more thing, Lordship, whether it is.
But this is something else. You see, correct. In a trial, we cannot look into.
Lordship,
In
But-
course of the trial, the absolute bar, except for contradiction.
one more thing I found in this, Lordship, in
Yes.
43D. Lordship raised that point on last occasion.
Yes,
43D, two twin conditions are there in proviso.
yes,
In that twin condition, one is regarding case diary or the report under section
yes, correct,
173.
correct. Either of
Then-
the alternatives, one, A or B.
And what I found after reading this,
Yes.
Lordship, actually, the case diary before submitting of the search sheet,
Correct.
if one search is submitted with all the opinions, whatever made by the investigating officer during investigation, he has made an opinion with his report. Then the use of case diary is not there.
What is
So,
it? No, okay,
the-
fine.
Lordship, what the interpretation I found in the books, Lordship, after that, Lordship, the case diary is, as Lordship mentioned earlier also, it's a day-to-day exercise of the investigating officer. After that, if the diary cannot be used during the evidence, then that has no evidentiary value, as he has made an opinion with his report, which he has to file under section 173. If Lordship pass an order after filing of charge sheet, then Lordship must have to look into the report submitted under section 173. I
Correct.
found after perusal of this, I found it.
So do you have any judicial decision in that regard?
Yes, Lordship, I got, but I could not print out this thing. I will submit this, Lordship.
Okay, then you submit, because this is, we also feel this is a very important area. There's
Yes, yes.
some, appears to be some vagueness.
And regarding this statement under section 161, what I found in the Evidence Act under section 25 and 26, if a statement before the police under the police custody, in that case, that must have to record before the magistrate.
No, that is no issue on that, not on that. That is another issue.
Yes.
That is another legal issue. But here, yes,
Oh,
Jahan, do you have any idea? Very interesting question of law. I know you are not in this case. Just out of
Academical discussion.
out of just purely academic discussion, nothing to do with the merit of the case at this stage, because Devi says that her senior is engaged in, therefore we are not taking up with that matter. Just because, see, if you read section 43D proviso, do you have a
Yes.
copy of that?
In fact,
Just give a, yes, lovely, give a copy to
in
Jahan.
fact, Mr.
Just-
Mishra did so many cases on 43D.
Huh,
I had almost marked
correct.
it, but
So therefore 43D is very interesting.
it's
Yeah.
it's in a couched in negative language. Yes.
Yes, 43D.
Hmm.
Provide.
Yes, 43D5.
Huh.
My Lordship,
What
this
is
one
the-
point.
Notwithstanding anything contained in the code,
Now come to
Provided-
the second proviso, provided that.
provided that such accused person shall not be released on bail or on his own bond if the court, on a perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true.
Okay, now we will not go to other aspects of this proviso.
Yes.
Only thing, what the proviso provides is that he shall not be released on bail, number one.
Hmm,
When he shall not be released,
Mm.
if the court is of opinion that there are reasonable grounds for believing that the accusation against such a person is prima facie true,
hmm.
how does the court come to that opinion? On the
a
basis of consideration of the perusal of the case diary
case diary
or
or
Report under.
report.
report.
Now, if you say therefore A or B,
A case
A
diary.
case diary,
Huh.
B report,
Report is charge sheet.
charge sheet 173.
Huh.
Now, when you say case diary contains everything.
Huh. Yes.
Case diary is all the observation, whether admissible, non-admissible, immaterial. Case diary means is a compendium of the facts, observation made by the IO
Yes.
during the investigation. That's case diary.
Huh.
Case diary does not say that no, if the evidence is not admissible, you shall not enter in the case diary. In fact, he will enter everything. His opinion, he
Yes.
thinks, what he
Day-to-day
observed.
works.
Whatever he thinks is relevant, will record it. It may be ultimately may not be admissible.
Yes.
That's a different aspect. But he will note down everything.
Everything.
So the case diary, when we say case diary, it contains all facts which may be admissible, may not be admissible, which may be relevant, which may not be relevant.
Yes, of course.
It is for the court to decide later on.
Hmm.
Now, but nevertheless, the fact remains as case diary contains all these facts, all bunch of facts. Number one, 173.
This is the.
Then there is some
ultimate-
application of mind by the prosecution
Yes.
also.
Hmm.
Oh, this we don't want it.
Hmm.
This is perhaps necessary. Perhaps this is relevant. So there is some application of mind by the prosecution before it is laid, report is submitted.
Procedure, yes.
Because you apply your mind.
Ah.
We have conducted this investigation.
And we
now
have
this is our view.
sufficient Evidence.
Now these are evidence.
Hmm.
So and so now we want to charge him for
Yes.
committing this offense.
Hmm.
That's in substance 173. And obviously they would not normally include things which are not admissible law, though they may also include it. But then that is for the court to
Yes,
see,
shift the
see, yes,
step.
just to separate it.
Ah.
Okay, no, these are not admissible, these are not relevant, these are not admissible, whatever it is. But then nevertheless, there will be some application of mind by the prosecution also. Oh, these are the evidence which will stand the scrutiny of the court.
Ah.
They may be right, they may be wrong
Yes.
in their assessment.
Hmm.
It is for the court to decide. But there is some element of application of mind when you make 173.
Yes.
Therefore, in the process, you normally do not take into consideration which you think that it is plainly illegal.
Ah.
Normally.
Yes.
So, what the difference between A and B is that A contains everything. B contains normally, which is permissible in law. To some extent, there has been some filtration has taken place
Yes.
before you make a report under 173. But UAPX says either A or B. If you take A, it may contain many more damaging material against the accused,
of course.
though it may not ultimately stand the scrutiny of law. It may have various, evidence, recording of facts, observations, That is case diary. So if you look at case diary, he will be more prejudiced.
But then again, Lordship will apply the law.
No,
again,
no. That is what we are
separate.
coming. That is what we are coming. Now, but when you say 173, you see, it has gone through some filtration. But when you say case diary, pure simple evidence, whatever the IO has collected,
Yes, legally, illegal. what-
legal, illegal, which includes 161 statement,
Yes, which are not.
which
yet-
says all, he's saying all kind of things.
Uh-huh.
Then the prosecution is, the defense saying, no, this court cannot look into it because that 161 cannot be linked to it because of interdict of 162. Fine, but that is at the stage of
Trial,
trial.
not now.
We are
at
not
the
in
stage
trial,
of
we are
bail.
in bail.
Yes.
But then trial has commenced also. That particular witness may have been examined also. He may have been already discredited also. He
Yes,
may
he
have
may
also
have
said, he may say, okay, yes, when I, for example, a confessional statement, yes, when the confessional statement is examined, the court will see, okay, confessional statement 164 CRPC. Did you take all those precautions? No, not prima
guidelines,
facie, no, this, we don't want to see this confessional statement because no warning, nothing, just brought and recorded. It doesn't appear to be.
Volunteer. But then
But then this is a confession statement 161 or 64 in case diary.
there those rigors of 164 is not there.
So, but in the trial,
It will come.
already here the witness has been examined. He has also, the defense has been able to point out so many defects, which creates a doubt on the genuineness of the confession, voluntariness of the confession.
Now,
So-
whether those will be considered during this bail,
Ah,
because here otherwise. by reading
otherwise,
This proviso, it will
yes.
not include.
So
either
therefore,
testimony or report.
therefore we'll ignore whatever is happening in the trial, according to you.
Not according to me,
Huh?
from, yes,
No,
from.
no, no, I'm not saying according to your view,
Yes,
is that
from
it will
the,
be totally ignored.
yes, from the provisions of this proviso. Because it is case diary order report.
220, William Bracket 2.
Will come into,
Why?
Article
Why-
20.
why use his own statement against him?
yes, yes.
There will be certain judicial precedents saying
That is
whether,
what we want to be little bit more clarity. We want more clarity on this issue. Mr. R.K. Dev Chaudhary,
is there.
we want some more clarity and do you have some judicial decision in this regard?
Not a decision, but it only says 161 and 164. Now, 161, I have to go through the facts of the facts are not discussed in the judgment.
So I think you please do little bit more exercise in that.
Yes.
Because see, ultimately,
Something, Lordship,
because we have to decide on this issue,
Yes.
because this, since the issue has cropped up,
yes.
this year that way,
Uh,
because you would say that you can't use this because of 162, this cannot be used. Even though the proviso says case diary, but still, when you say case diary, what is prohibited to be used under law cannot be used.
Yes. Yes, madam.
What yes?
Yes.
What do you say? What is the judgment? Tell us, tell us. This is how we are just
In this judgment.
in the judgment. What?
But this doesn't appear to be correct because
Huh?
a case diary, the materials will have to be considered. Now it will be hit by 162 and all will come in the trial. As far as bail under 43D5, dissatisfaction is concerned, I don't think so. Those rigors of section 25, 26,
See,
162.
correct. That is what, when you are saying you don't think so, when you say you don't think so, if you can support by some judicial decision, it will be much easier for us to. Otherwise, we'll write our view. We are not saying that.
Lordship,
We'll give our view on that. But if you have some decided judicial decision, we'll try to understand better this issue.
Some high courts must have pronounced something. We'll get it.
yes, Lordship,
You don't go for SCC or Supreme Court because these are issues
No.
many decided in the High Court level.
Bombay High Court decision. Lordship.
Bombay High
But
Court.
It is in Manupatra. I have no Manupatras.
I have.
Then you ask
Manupatra.
Jahan, she has got Manupatra.
I can download it from our High Court, Lordship. in
So
our
whatever, what we are trying to say,
But
we'll be
here
happy.
one more point is there in Evidence Act 145, section 145 is there.
Oh, Miss, that
No, no,
145 will apply when the trial is being conducted, then
That
the,
is true.
but
If-
this
if
is not a
the-
trial.
no, if
So
the-
you cannot use, you cannot contradict.
Lordship, if-
There is no witness to be contradicted at
if
the
you
time of
Lordship-
constitution
if
of bail.
Lordship, during investigation, something he has to brought before the court. And if he bring these things, in that case, that must have to prove. If he cannot prove that thing, in that case, this cannot be used against the accused.
Correct, but then the contradiction has to be with the witness, not the document as such. The contradiction for contradicting, the contradiction must be of the witness who is testifying.
Yes.
That stage has not yet come. In the bail stage, we don't examine witnesses, only the documents, materials, case
Yes.
diary.
What documents they have produced, Lordship, in this case? Against the accused person.
Correct, we'll see that. That will take a appraisal, will make an appraisal
And
of
as
the.
per proviso, what my understanding is that if proviso, if we go, then there are two conditions. One for case diary and other for 170.
Correct, but then the
but
law permits both.
No,
It doesn't say case diary, and in absence of which, or see the law is it gives option to the court to either use case diary or the police report.
If once,
If you are able to show
yes,
with some decision that
yes, yes,
once report has been prepared,
yes.
you cannot look into the case diary. Then is another thing.
If,
If
the
the report has been prepared under 173,
yes,
then you cannot look into the case diary.
if court cannot take it as evidence during the trial, the use of this, nothing, Lordship. That is why if final opinion submitted by the IO under 173, the 172.
Therefore, we are saying, yes, we are saying that you cite the judgment that
Definitely.
once a report is prepared under submitted under section 173 of CRPC, the case diary becomes redundant. It is superseded. It has lost its value. Therefore, even if the act says case diary or the report, we must look only at the report, not in the case diary.
And
Because case diary has lost its value.
yes,
It has been already scrutinized.
and one more thing in 170.
We have to argue in that manner also. Then
Yes, yes,
we
Lordship.
can perhaps look into the aspect.
Lordship, in 170 to 1.3, subclause 3, one more thing is there. Neither the accused nor his agent shall be entitled to call for such diary, nor shall he or they be entitled to see them merely because they are referred to by the court. But if they are used by the police officer who made them to refresh his memory, or if court uses them for the purpose of contradicting such police officer, the provisions of section 161 or section 145, as the case may be, the Indian Evidence Act.
There is no doubt about it. There is no issue, but that is not at a time of consideration of bail. There is no time, that is at a time.
This is not mentioned in anywhere because
So then you argue on that. We are
Yes.
giving you that. We are not saying that you are not, what you are submitting is not correct. These are all probable areas. You argue that yes, what is prohibited by law, even if it is contained in case diary, cannot be used. According to it is prohibited by law.
Yes.
Under 162.
yes,
Therefore, even if it is found in case diary, the court should ignore it. Some judgments, then it will make us our exercise easier. Otherwise, we'll give our view. Once this issue has been brought to our notice, we have to give our views. We'll give it. But if there is some already view expressed in other court, we'll see.
okay. One more query is there, Lordship. If case diary produced by the honorable court during the bail, in that case also, if that cannot be used in evidence, then that part cannot take up by the honorable court against the accused.
Correct. No, but you see.
But in our case, they have placed everything.
Whatever it is, we are not on that. See, Nargis, we are considering at the consideration. We are at the stage of consideration of bail,
Yes.
not a trial. So, what is the law applicable in course of a trial or during trial? Let us not bring.
That is not expressed in this.
Yes, you can argue also.
Yes.
You can argue also. Yes. Yes, even though we are considering bail, yet those principles can be also used. You argue that. You have no problem.
This or case value appears to be marginally opposite to this. What is stated here? What is stated here appears to be opposite. to
Correct.
this.
Correct. But then this is also
This is creating confusion.
172, no?
Yes. What is
But-
stated here in part 3, what she said now,
Mm.
appears to be just opposite to case.
But this is doing investigation now. Investigation, you are doing investigation, you are not
Yes.
then case diary loses its value. Therefore, the court should go look into the
173.
173. That has to be your argument.
Yes. I have
Mr. Arke-
mentioned, I have mentioned that too.
Oh, you have mentioned, we are also saying,
Yes, Lord.
but no, we are not deciding it.
Yes,
But
yes.
that can be the argument which you can put.
Yes.
But show some judgment if you have. That's what we are asking.
Definitely, Lordship. Because of Lordship query, yesterday I bought this question.
Otherwise,
Yes.
you wouldn't have bought it. Huh?
Other,
But without it, how will you be a practicing a lawyer?
otherwise, we have this one.
Only this will suffice.
New edition. This is new edition.
You should always buy the latest edition.
Yes, yes, new edition.
See, we are trying. See, R.K. Dev Chaudhary. When bail is considered at various stages,
Yes.
when a complaint is filed, investigation started, then the picture is not clear. Still, people say, no, there is nothing. There is nothing in the FIR, nothing. The police has done investigation. He has arrested so and so, but nobody has implicated me. So kindly grant bail. That's the usual in bail. Nothing has been said. He is the main accused. He has not even mentioned my name. So much thing has been recovered, but nothing to implicate me. I am unnecessarily being dragged. Please grant me bail. Then we look into case. They call for the police report. The police submit the objection, bail objection. They will write on the basis of investigation they have done. So and so, so and so, so and so. Then the court will look it. Okay, grant. Okay, reject. But when the trial has started, then he said no, and nothing. Even during that 227 charge consideration,
Yes.
There
228
also-
charge.
228. There also he is entitled to ask. See, there is nothing. Though so many things are written against me in the case diary, no value, no worth. All are confessional statement made to the police, in custody or into the police, all inadmissible under section 25 or 24 of the evidence.
25, 25, 26.
I said, therefore,
Evidence.
no case, throw this out. Acquit me. Or if you want to, at least grant me bail. And nothing, no material.
Lordship, the interpretation would differ from stage to stage.
That is what we are asking.
Yes.
What is the fact situation now today is a trial has commenced. Trial has commenced on the basis of certain charge sheet framed. Charge sheet is framed on the basis of certain evidence. Whether these evidence will be sufficient in ultimately to sustain the conviction is another issue. We are not called upon to examine.
Lordship.
We are only called upon to examine whether to grant bail to this person or not. To consider it, there may be some material which we have to look into. What do we look into? Case diary mentioned in the section provision to section 43 or the police report, because these are two different documents. Case diary is a bundle of whatever facts gathered, relevant, irrelevant, admissible, non-admissible, all bundle of facts, case diary, all bigger, truckload of bundle. And when you reduce it to charge frame, you also screen out all those and thin down. The volume is thin down. When you file a charge sheet from truckload to a car load only. Because you feel that these are all unneeded. Though we had concern, but no, not relevant, useless, this, that, reduce. More, actionable evidence.
Which
Because
can they
we,
establish?
you think that because of this evidence, we'll able to convict Nargis and send her to jail. That's what you are confident. That's why you file. It goes through all various channels. Prosecution applies, director approves, sanction, everybody applies their mind. Okay, very well. These are documents we think will sustain the charge against Nargis. Charge sheet is filed.
That should be applied for under section 145 of Evidence Act. That is
Madam, you are again.
Discussion, I'm telling this
Why you are bringing 145 again and again?
again and again, Lordship,
Because in bail, we don't examine any witness.
no, what document they will rely.
Arey Baba, unless you cross-examine on that by pointing out those facts, what you state in 161, how, what,
That is the thing,
what
Lordship.
the,
That document they have to rely in their final report.
oh, again, you are making yourself confused. That stage has not yet come for purpose of bail.
That is not mentioned in the section, in this section.
Lordship,
Lordship, that is not mentioned in the section. In proviso, two things mentioned. Only the.
Oh,
report-
just because it's not mentioned, that doesn't mean that you can use it, because that is to be used, that 145 is to be used only during the trial, when you confront a witness, saying
No,
that
I'm
you
not-
are,
Only thing.
when you confront and contradict him.
Lordship, I'm not on that. Only thing is that if they file any document, that document must have to prove by them.
Oh,
That
they will
is why-
prove, of
that
course.
is why They have to file the documents which can be reported under section 145 of Evidence Act.
Oh, that is their problem, their headache. Why you bringing? You cannot bring at this. You cannot argue on that.
No, that is
And that
why.
that is the
that
stage.
is
That
why-
is not the stage in bail that you can argue on that. That you can argue later on.
No, Lordship, it's a case and after filing of charge sheet.
Whatever it is. So, what are the materials which can be looked into by a court while considering bail? It is the issue before us.
Lordship, let me look into few high court decisions. Of course,
Yes,
Supreme
please
Court
do
I
that.
have got, but this is not very clear. It only lays down the law.
Please do that. Please do that. Because it is very important also. We feel that it's very important.
Here it
Because
goes-
if we look purely on the case diary, there's so many material against you.
So then Lordship has to look into everything. Lordship cannot skip.
That's what, see,
that.
see, RK Dev is saying, see, Nargis, RK Dev is saying, this court has to look to case diary, everything what is there in the case diary.
Lordship, one more thing I found.
Because the law says so,
No.
case diary or,
One more thing I found, the court is entitled for perusal to enable it to find out if the investigation has been conducted on right lines. 172 is like that.
or that is before the,
Not
But
for
that-
using of against the accused.
Investigation, we are considering bail after charge with evidence, but 172 is investigation. stage.
investigation stage.
Yes,
Sometimes police may go here and there.
yes,
Yes.
yes. Not a case is after,
So you argue, Nargis, we have given you sufficient hint to you.
yes, definitely.
We cannot go beyond this.
I'm very much
Because
obliged today.
hint in the sense, because these are issues which is also in our mind, what is to be done? What are the documents, what are the materials which we have, we can look into at a time of consideration of bail.
This is perhaps an area, Lordship, I have not come across any judgment of this honorable court, at least on this point.
No, fine, then you assist us
Yes,
to
yes, I will
make
try
a
to do
good law on
something
that, because see,
but
whether he gets bail or not, it now on certain principle of law, it must be, so the principle of law must be clear. Then whether he gets or not, that is another issue. That is the application of the principle. But what principle we must evolve and we must adopt, we must apply, that must be clear to us. If there is some vagueness in that, let it be clarified. We
Lordship,
feel that there is some element of, vagueness, ambiguity in this
this provision.
proviso,
Proviso.
in this
Yes.
proviso.
Yes, Lord.
What, yes.
Yes, I got it.
Do you do some homework on that?
Yes, I'm doing Lordship.
Huh?
Still, I'm searching in this Lordship.
And do some homework,
Yes, Lord.
spend some more time with Durga Puja. Huh?
Again, I'll look into that.
Please do that, because this is what we felt is a very important area.
Yes,
Because
To that regard, I talk with her lots of time, Lordship.
yes, so she
I-
told me about this.
yeah, because this principle, we also want to be more clarified.
Had it
You want
been
more
not-
clarity on this.
yes, had it been not a or, if,
Yes,
Or-
yeah, had it been a comma,
comma,
then
huh.
we could have applied adjustive generous and then apply everything.
Yes,
Yes.
yes.
Case diary, final report, the documents that have come during the trial.
Yes.
Everything would have been included. Had it, we could have.
And whatever provision of law must be in tune with the basic constitutional safeguard.
Yes.
It must be in tune with the basic constitutional norms also, and the general criminal jurisprudence of the country, unless the wording, the language is very, very categorical,
Yes.
unambiguous.
Yes. No
If it is unambiguous, the question of
Ah.
again bringing constitutional norm, this and that may not arise.
When there is.
But
no
if there is
mystery-
ambiguity, then what kind of interpretation we adopt? We must adopt that interpretation which is in conformity with the criminal jurisprudence, which is well accepted, well settled.
Here it is very clear, case diary or report.
Is there a
Now the
report?
question is, after filing of report, no case diary,
Yes,
that has to be again interpreted.
yes, yes. Can you still look into case diary once the report has been filed?
Mm.
Because by the time report has become redundant,
Ah,
Yes.
in law, the case diary has no more value.
except
Once
contradict.
till
Ah.
investigation stage, case diary has all its importance, significance.
Mm.
The moment say, yes, report has been prepared, the case diary goes into background. It goes to the background. Then if that is which is gone to the background,
Whether that
can
is-
you retrieve it? Saying,
Mm.
no, 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 I want to see the,
Yes. Or whether the subsequent depositions could also be considered. That has to be again. seen.
there again another issue.
This issue raised by your lordship earlier also, this regarding this consideration of the deposition of witness or not.
What did you, I raised it, but
But I
have you
will
given
reply-
any answer to it?
Yeah, no, lordship, because their turn, I will reply to
What
that.
is by their turn? It is your duty also to see.
I'll reply to that.
What, you are not replying also.
Their turn not yet completed.
But this is a legal issue which we also have to
Yes, sir.
address.
I talked with Ms. Jahan to that
Yes,
regard.
she
Yes.
spoke to me.
Lordship, our expert here is,
Oh,
so we all look forward to her.
highly obliged.
Now we want to see some more clarity on this issue.
There will be some, there will be some.
I am sure there must be some, see, if we flip through there, thousands of cases being decided in this country in lower courts, no?
In the
Even
other high
though,
courts.
even though it may not be UAP Act,
Yes,
it
yes.
may be some normal act. So somebody may raise an objection. No, no, Your Honor, you cannot look into this. How can you look into this? Now is a trial stage. How can you look into this case diary? It has been discarded by the prosecution.
Mm.
Only adopt a certain portion of it. That's how they have filed this charge frames. Therefore, you can't look into that abandoned house. You have to go to a new house, which have been adopted by the prosecution. That is an old house, old farmhouse. The prosecution has built a new house.
I think there is a similar provision in Tada Kota or somewhere.
Yes,
See,
yes.
see, see.
This 43
I
D5.
found
What?
this
Yes,
in-
yes, again.
Lordship, I found in this book, but little bit time is required.
You take your time. You, if needed, you buy more books.
I mean,
Uh,
vacation. There will be no vacation for us because of this case.
Good for everyone.
ঠিক আছে, না?
Okay, then we'll have,
Can we fix on 26th? Lordship?
see 26 may be some difficulty because there's some, let it be on November.
Lordship,
Because the 26, because